Hi everyone, it's Mark and Korshik from Chartergate Legal Services, and we are going to be talking about the Employment Tribunal time limit changes that have come about following the Employment Rights Act. As you know, Korshik, for years and years, the main method for an individual to enforce their employment rights is at the tribunal. And for years, there's been two main time limits, depending on the type of claim. Either a 3-month time limit or a 6-month time limit, with relatively strict rules in terms of allowing a claim if the claimant isn't in time. So that's been the position for a number of years. What's the Employment Rights Act changing?
Well, Mark, the key one is the 3-month time limit. That is the time limit that applies to the vast majority of claims. So the claims that you probably are most familiar with are unfair dismissal, discrimination complaints, whistleblowing complaints. Now, at the moment, we have that primary time limit of 3 months, although before any employee can actually bring a claim, they have to go through ACAS first. And that involves going through a process called ACAS early conciliation. So what does that involve? Well, it means going to ACAS, filling in a fairly simple form, and going through a process called conciliation. Now, that has a minimum time period of 6 weeks, can extend up to 12 weeks. So we're already potentially at the 3-month time window. But why is that important? Well, it's important because for the time that somebody is going through early conciliation, the clock is frozen. It's not moving. So in total, we already potentially have a 6-month already, a time limit already in place. Now, what the changes propose is that primary time limit to go to ACAS is going to essentially increase from 3 months minus 1 day to 6 months and minus 1 day. So the total time limit, the total time to now go to an ET is going to be closer to 9 months. So if you see how that might work, I suppose, in practice, a lot of employees, and I've certainly found this, a lot of employees, they leave an employer or they're dismissed. Sometimes employers and employees, they're not leaving under the best of circumstances, and they think about it, but by the time they actually get around to bringing a claim, that time window has already passed. Now they potentially have a full 9 months or so before actually being able to bring a claim. Okay,
so that's a new 6-month time limit.
New 6
plus the early ACAS early conciliation.
Exactly.
Okay, so are the rules changing in terms of a claim being allowed where it's potentially out of time? So I know that at the moment, the tribunal looks at whether it was reasonably practicable for the claimant to make the claim within time, and often they enforce that time limit quite strictly. You know, there's been claims where a claim hasn't been allowed and the claimant was only, 11 minutes late. Are those rules changing as well?
No, those rules are essentially the same. So we have our primary time limit, but we also have a discretion that the tribunal has to be able to extend time. Now, the discretionary test is going to vary according to the kind of claim being brought. So the most common claim that you'll be familiar with are things like unfair dismissal. The time limit there is in practice quite strict. So miss that primary time period, currently 3 months minus 1 day, soon to be 6 months minus 1 day, and that's it. It's very, very then difficult to be able to extend time, the test being that it's not reasonably practicable, and that often requires quite a lot of effort and evidence from the claimant to be able to persuade a tribunal. Discrimination claims, much easier. The test is much broader, gives the tribunal much more discretion to be able to extend time.
Okay, so the reasonably practicable test doesn't apply to claims like discrimination?
It doesn't, no.
Okay, so what's the test in those circumstances?
So the test there would be whether it's just and equitable. Now, that's a very, very broad test. I mean, what exactly does just and equitable mean? Well, a variety of things. The tribunal can look at the reason, the balance of prejudice to the various parties, whether fair trial is possible, all sorts of factors. It really is quite discretionary. And more often than not, my experience has been that tribunals tend to allow claims, even those quite significantly out of time in, where there's a just and equitable discretion for the tribunal to extend time.
Okay, so we've got extended time limits for claims.
Yes.
How should employers be going about operating in that new world?
Well, key really are policies and processes. Okay. So at the moment, with a shorter time period, a lot of employers have perhaps taken the view that, well, we only have to hold out for this time period. Yeah. After that, the chances of somebody successfully being able to even bring a claim to the employment tribunal are relatively low. But with that extended time period, we can expect that there are going to be an increase in claims. In short, more people are going to bring claims.
Yeah.
And what does that mean? Well, that means that we need to be more careful, ideally, with dismissals. We need to think about our disciplinary processes. We need to think if, for example, we're dismissing for performance reasons, that we have a clear performance process that managers understand.
Yeah.
And that they follow through with, that it's documented much more comprehensively, because the chances and likelihood now of somebody going to a claim are significantly higher. And likewise, I suppose, where you have those claims such as constructive dismissal, where someone resigns and claims that they were improperly treated, often tribunals will look for evidence of complaints having been raised and also investigated. So grievance procedures, really important that those are updated, that those are followed, and that comprehensive records are retained.
Okay, so to summarise, make sure your policies and procedures are up to date.
Yes.
Make sure you're following them in practice. And I suppose proceed on the basis of expecting more claims, and therefore make sure you are following your policies and procedures. Would you say that's a fair summary?
That's a perfect summary, I would say.
Okay, and so just looking at this in practice, often businesses will look to a settlement agreement, whether it's via ACAS or independently. How do the new time limits to make a claim affect that?
Well, ostensibly, a settlement agreement is going to be a separate process to going through the tribunal. So in one sense, it doesn't affect it. I suppose where it potentially does, though, is obviously the leverage is significantly higher if somebody's out of time to be able to bring a claim, as opposed to where they have 9 months now in total to potentially be able to bring a claim. So I foresee that settlement agreements are going to become much more prevalent and prominent.
Okay, so essentially more time to negotiate before the claim needs to be made.
Yes.
Okay, and we've got new time limits to make a claim. Are any of the other time limits changing after that? So, for example, the respondent needs to get their response in by a certain time limit. Are any of those changing?
No, those are staying exactly the same. So claimant gets more time. Employers and respondents get the same time. Okay,
fair enough. So just to finish up, Kaushik, the new time limits to make a tribunal claim, are they in force yet?
Thankfully not. Not till October 2026. So we have a little bit of time, but not a lot.
Okay, so they're coming in on October 26, and then the unfair dismissal qualifying period changes are coming in January 27.
That's right.
So a bit of a double whammy for employers.
Absolutely. And collectively, that's going to have a significant impact on employer-employee relations.
Well, thanks for that, Kaushik. And if anyone's got any queries or questions following on from this video, then just get in touch and we'll be happy to help. Thanks a lot.